In addition to other cases, we handle a lot of motor vehicle accident cases here at the firm. And something we get a lot from clients is the fact that I have some dings on my prior driving record going to affect my case? And I want to talk about that a little bit. So I can't think of very many people who have no blemishes on their driving record. A blown stop sign here, a speeding ticket there, maybe a fender bender over here. Generally speaking, a person's driving record is not admissible in a civil case for auto negligence. But that's not to mean that it never comes in. So if there is an allegation that the driver's competence was at issue, now this usually comes up is if the driver had no driver's license at all and had rarely driven a motor vehicle. Now that possibly may be able to come in to show that that driver was not competent to be on the road and couldn't really appreciate whether it was safe to make a turn or pull into an intersection or whatever it was that contributed to the accident. Another big issue that is usually heavily disputed in motor vehicle cases is medical causation. And this is an area where your prior accidents that you've been involved in would likely become admissible. The defense would likely want to bring up the fact that you were in other accidents, especially if you were injured in those accidents or had significant medical treatment following those accidents, because that is a very typical argument that is used to say that whatever injuries and medical treatment and pain and symptoms that you're alleging you suffered as a result of this accident, the defense likes to argue that that has nothing to do with this accident, that likely was caused by one of these prior accidents and was already existing at the time that you were in this accident.